Do we have monkey selfies to thank as the reason why AI-generated images can't be copyrighted right now? Let me explain. In case you're new here, we're Apartment D Films, an indie stop-motion animation studio with our own indie animation hybrid series that wants to see our fellow creatives succeed, especially now. This time with some good news, because the US Supreme Court recently declined to hear a case involving whether or not art generated by AI can be copyrighted, thus upholding previous court rulings that a human author is required for work to be copyrightable. Right now, this is great news for artists and hopefully a step in the right direction for AI regulations. But where did the previous court rulings that deemed a human author necessary come from? The story starts back in 2011 when British wildlife photographer David Slater was in Indonesia, taking pictures of crested black macaques in the wild to raise awareness for the endangered species. He couldn't get super close shots of them without scaring them off, so he meticulously set up the camera in a much less invasive way so the monkeys were able to take pictures of themselves with the camera release button. Basically, the monkeys took selfies. The results were these pictures, which you might have seen floating around on the internet back in the day. He licensed the photos to news outlets, to which he explained how he took the pictures because that's an interesting story. This got the attention of Wikimedia Commons, who saw the story and said, actually, these photos belong in the public domain and not to David Slater, because David Slater did not take these pictures. The monkey did. And because we can't give the copyright to a monkey, it belongs in the public domain. Slater tried to argue that he made extensive preparations and important contributions that led to the existence of the photos, but it wasn't until 2014 that the US Copyright Office released an opinion clarifying that, quote, only works created by a human can be copyrighted under US law, which excludes photographs and artwork created by animals or machines without human intervention, citing a photograph taken by a monkey specifically as a case of what can't be copyrighted. As upsetting as this might sound right now for Slater, it would be this decision that would help him later when he was taken to court for a different situation. In 2015, he published a book which included pictures of the monkey selfies, where a portion of the sales made would be donated to causes helping the endangered species. You'd think that's a nice thing to do, considering all he just went through. Well, PETA, the controversial animal rights group, didn't think so. They would file a lawsuit against him and the publishing company using the next friend principle, requesting that the monkey get the copyright and that they would handle the funds to ensure macaque well-being. The case was called Naruto versus David Slater. They named the monkey Naruto. Thankfully, the court would end up ruling in Slater's favor on the basis that copyright law does not apply to animals. All of that to say, this is why art generated by AI cannot be copyrighted. Even though David Slater did all of the prep work that led to the existence of the monkey selfies, it was the monkey that took the photo, and because of that, Slater could not get the copyright. Apply this to today. If Bob were to type in a prompt that led to the existence of an AI-generated image, it's the AI that made the image, and Bob would not get the copyright. Did you already know this story, or is this news to you? Let us know in the comments and like and follow for more.